Today we're here to discuss the judicial branch and the court system, and so our goal for today is to explain the difference between a criminal and a civil court system. Many times in the United States we consider ourselves a dual court system. We have two different courts, and what makes it tricky is they both meet in the same building, but they have different types of cases. So the judge would be the same judge, same court, same building, but they would have different cases, and that's the difference between civil and criminal court. Civil court means that you have offended somebody else and you're suing somebody else. Criminal court means you have committed a crime and you potentially could go to jail because of that. So we'll take a look at the differences in a second. Of course, inevitably, we've already looked at the case of the shipwrecked sailor and the case of the unclear law. And the one thing that we realize is that no matter how clear we think a law is, everything is open to interpretation. Whether or not driving an ambulance across the lawn or a bicycle or a baby stroller, technically, is that a vehicle? Is that not a vehicle? Is it permitted in the park? Is it not permitted? Or looking at the case of the shipwrecked sailor, anybody who has deliberately taken the life of another is guilty of murder. Well, the question is, did they do it? Did they not? Should there be an exception? And that is the reason why we have a judicial branch. We've talked about the purpose of a judicial branch is to interpret the law, to interpret the Constitution. And when we weighed what should happen in the case of the shipwrecked sailor, that's exactly what we were doing. We were interpreting the law. So there are two different ways to look at the role of a justice in interpreting the Constitution. There are what are known as a strict constructionist. Those are the people who believe the Constitution means what it means, that it should be interpreted word for word exactly as it is written. Today, if you listen to the news, you might hear the term judicial restraint thrown around. And what that means is the justice is restraining themselves. They are refraining from really trying to interpret the Constitution and really sticking with what they believe to be the direct meaning of what was actually written in the document, what was actually written in the Constitution. And so somebody who believes in strict construction believes that the court shouldn't interpret the Constitution, shouldn't change the Constitution, that the founders meant what they meant and whatever they wrote exactly as they wrote it, that is the law, that is the way it should be interpreted. Now, a liberal constructionist, as you might imagine, is somebody who believes in just the opposite. And today, if you hear that term on TV, you're usually talking about a judicial activist or somebody who is practicing judicial activism. And what that means is they're more willing to interpret the Constitution. They're more willing to consider that the Constitution has at least a slightly different meaning from exactly the way it was written. And so that is the purpose of the court system. If we look at the Supreme Court, the current Supreme Court, this would show us sort of where they fall on the political continuum. So we have somebody like Sonita Sotomayor, who is more of a liberal justice. We have Clarence Thomas, who is more of a conservative justice. And somewhere in between, we've got people like Breyer and Kennedy. You can take more of a look at that on your own. So again, if we look at the three branches of government, we know that Article 1 sets up the legislative branch. Their job is to make the laws. Article 2 sets up the executive branch. Their job is to enforce the laws. And Article 3 sets up the judicial branch. Their job is to interpret the laws. So again, if we're looking at interpretation, essentially we are looking at either judicial activism or judicial restraint. So the Constitution itself, we know Article 3 sets up the judicial branch, the part that interprets the laws. The other thing that Article 3 does, the other thing that the judicial branch does, is it settles conflict. Anytime there's a dispute or a conflict, instead of the old days of having a shootout or having some other type of physical battle to decide who's right, instead we have the Constitution, which says the court can discuss things, talk it out, and find a civilized solution to any of our problems. So looking at the role of the judicial branch. The judicial branch in America is an adversarial system. And what that means is you have the right to confront witnesses. You have the right to confront your opponent. Instead of just letting some guy in a deep dark room decide your fate or future, it is up to both sides to make their case in an open courtroom in front of what we would call an impartial jury. And what we mean by impartial is somebody who has no bias, somebody who is not in any way related to the case or has no prior knowledge or bias involved in the case. When we look at the purpose of the judicial branch, we can say that there are a number of purposes. Number one, to help people avoid and resolve conflict, but sometimes we know that conflict is going to happen. We hope that the judicial branch will deter that conflict, but if it doesn't, the job of the judicial branch is to resolve that conflict. Another thing is every community has a different goal. We've talked about why do people live in groups to meet their needs, and every community has different needs, and the judicial branch helps the community meet those needs. We know that the judicial branch is there to respect the will of the majority while protecting the rights of the minority. We talked about this with core democratic values. We said the will of the majority, whoever is in the majority usually is right in America, but we know that there are some things that even if you're in the minority, your rights are still protected. And the point of the judicial branch is to protect those rights. The judicial branch is also there to promote order and stability, to make sure that we don't have people running rampant and killing each other in the streets to solve their conflicts, to resolve their disputes. And we know that the judicial branch, of course, is there to protect both freedom, liberty, as well as fairness, what is right. So those are the purposes of the judicial branch. Now, again, going to our main goal, the types of courts, if we want to take a look at the different types of courts, we have two different types of court in America. We have a civil court system, which is a dispute there to solve disputes between private citizens. So if my tree falls on my next door neighbor's house, then we could sue each other in a civil court. Now, the important thing to note about civil court is I am suing for restitution, or he is suing for restitution. We just want monetary payment. Nobody's going to jail. Nobody's going to get arrested. You haven't committed a crime, but anytime you are suing for restitution for monetary payment, you would go before a civil court. Now, a criminal court in America means you've broken the law. You have broken one of the codes that is written down by the state or the government. And so if you commit a crime, you're going to go to jail, or you're going to have to pay a fine or have some other type of punishment. And generally speaking, criminal court is when you break the law. When you break the law, the state is a party. So it's not two private citizens suing each other. It is the state taking you to court. And in essence, they probably want to either fine you or put you in jail. So if we want to look at the most basic outline of it, your book has this chart. I'll give you a second to look it over. Feel free to pause. And we move on. So if we're going to look at this dual court system, these two different types of court, we're first going to look at some of the basics of a civil court system. So again, we said that a civil court is a dispute there to solve a dispute between individuals. When two people disagree, they will go to civil court. So if mom and dad are suing in a divorce case, or if you trip and fall on my sidewalk, or if I'm playing baseball and I hit a baseball and it breaks your window, those are all disputes between private individuals. None of us is going to jail because of that. We're just trying to solve our dispute. We're just trying to solve the disagreement without actually fighting in person. So in a civil case, it's always a plaintiff versus a defendant. One person is doing the accusing, the other person is there to defend themselves. And one of the major differences between civil and criminal court, in a civil court, you have no Fifth Amendment right. When we talk about the Fifth Amendment, we talked about the right to remain silent and the right to not testify against yourself. You don't have that right in a civil case. You do in a criminal case, but not in a civil case. So if somebody's suing you, you must testify against yourself. In a civil court, we have a burden of proof. What we mean by burden of proof is how much evidence do we need to reach a decision? And the burden of proof in a civil case is much less than in a criminal case. In a civil case, you need what is known as a preponderance of the evidence. And generally speaking, the way lawyers like to think about this is you have to be more sure that they did it than that they didn't. More sure that they are responsible than that they are not responsible. So usually we call this about 51%. And so in a Civil case, if a jury reaches a decision, if they are 51% sure that the person is responsible, they are going to rule in favor of one side or the other. Civil cases are not guilty or not guilty, it's are you responsible? So civil cases always are there to decide responsibility. Is it my fault that you tripped on my sidewalk? Is it your fault that your baseball broke my window? We're just there to determine responsibility. Remember, in a civil case, no crime has been committed. It's just a dispute between individuals. In a civil case, the penalties are much different than in a criminal case. In the civil case, there is no jail time. You're not going to jail for losing a civil case. But where things do get tricky, you can be sued. And so one of the penalties is usually what we would call restitution or monetary compensation. Usually in most civil cases, what happens is you get money or you get payment to make up for the wrong that has been done to you. So if I hit a baseball and it breaks your window, you win the case, you win restitution. You're going to get money and you're going to have that money to replace your window. So we're just trying to make the right wrong. Criminal cases are much different. In a criminal case, the government gets involved. So instead of two private citizens suing each other, this is the government, or what is known as the prosecution, bringing the case against a defendant. And if you think, why does the government do this? Well, sometimes the victim, sometimes the offended party, is not there to advocate for themselves. For example, if it's a murder case, if the person's dead, they can't really sue somebody in court. And so a criminal case, it is always the government who is prosecuting on behalf of the offended. So even if you say, well, I don't really want to press charges, the government can still choose to enforce the law. In a criminal case, it is a little bit different than a civil case. You do have your Fifth Amendment rights. So if you don't want to testify against yourself, you can plead the Fifth Amendment, and you do not have to take the stand to testify against yourself. You can keep quiet, and that is not an admission of guilt. In a criminal case, the amount of evidence we need is a whole lot greater than what you would need in a civil case. In a criminal case, you have to be certain beyond a reasonable doubt. So in a criminal case, the amount of evidence that you need to convict somebody, to find somebody guilty, must be beyond a reasonable doubt. And what that means is you have to have probably about 99% sure that the person did it. You have to be pretty sure that it happened. Generally speaking, we use the number 99% sure. Obviously, unless we're actually there to witness it or there's a videotape, 100% sure is probably a little far-fetched. But you have to be about 99% sure in a criminal case. And of course, we know that in a criminal case, you are considered innocent until proven guilty. Until the prosecution shows enough evidence to prove that you are guilty, you are considered innocent. When they reach a decision in a criminal case, the decision is either guilty or not guilty. And technically speaking, it's not saying that you're not guilty of the crime. It's just saying that there wasn't enough evidence to find you guilty. It's saying you're not necessarily innocent, you're just not guilty based on the evidence, which is sometimes what we would know as an acquittal. Or you're found guilty, and if you're found guilty, of course, you're going to suffer some kind of consequence. In a criminal case, the jury must be unanimous. What we mean by unanimous is everybody must agree. Typically, a jury is 12 members. Sometimes it could be as low as 6 or 3. But in a criminal case, the jury always must agree with each other. You have to have a unanimous decision. If all the jurors cannot agree with each other, then we have what is known as a hung jury. When the jury doesn't agree with each other, that's called a hung jury. And if we have a hung jury, then we declare a mistrial. Now, a mistrial doesn't mean you're guilty. It doesn't mean you're not guilty. It just means that the jury couldn't reach a decision, and there's a chance that we're going to have another trial, and we're going to try the case all over again. Sometimes the prosecutor will say, we've already spent enough time and energy and effort. We're done trying this case, and basically, without any decision being reached, the person will go free. Others, you might be tried several times. For example, a few years ago, there was a Detroit police officer who was accused of murdering a young man. well in the line of duty. And his first trial ended in a mistrial. His second trial ended in a mistrial. His third trial ended in a mistrial. They could have kept trying him a fourth, fifth, sixth time. It doesn't matter. But after the third time, the prosecutor decided, look, we're never going to get 12 people to agree, so we're just going to drop the case. That doesn't mean the guy was found not guilty. It doesn't mean the guy was innocent. Doesn't mean he was guilty. Just means that there was no trial decision reached. In a criminal trial, the penalties are much stiffer than in a civil trial. Typically, we're talking about going to jail. That is the most common criminal punishment. Other types of punishments include fines. This time, though the fine is not paid to a private individual, it's paid to the government. So if you are caught littering or you're caught dumping waste in a certain area, you could be fined $1,000. That $1,000 is going to the state. It's going to the government. You could be put on probation, which means that basically you have to report to a probation officer. You're not going to go to jail, but somebody's going to keep track of you and watch over you, and you basically have to meet with a counselor. You could be giving community service work. So a lot of times on a early morning day, if you see the guys in the little orange vest cleaning up the streets and picking up trash, those are people who have had probation. Or community service, who have been required to do community service, sometimes as part of a probation hearing. And then in the most extreme cases, you could receive the death penalty for your actions if you are found guilty in a criminal case. Next, we'll take a look at the trial process. So how does a trial actually work? So even before the trial begins, we have to collect evidence, and in order to collect evidence, you have to have a warrant. And again, in order to have a warrant, you must get a warrant. You must have some evidence that something was done. Or if you don't have a warrant, you have to have what is known as probable cause or reasonable suspicion. That doesn't mean you have to know that the person's guilty. You don't have to know beyond a reasonable doubt. You don't have to be 98, 99% sure. You don't even have to have a preponderance of evidence, be half sure. You just have to have something that leads you to believe that the person has done something wrong. And so, generally speaking, if you look guilty, that's not considered enough, but cop sees you running from the scene of a crime, that might be reasonable suspicion in order to at least search you and see what they can find. If a cop believes that a crime has been committed, if there is a reasonable belief, then the next step is the cops have to go make an arrest. The police have the right to go out, they have the right to arrest you, and when they arrest you, they have the right to search your person. So if they find anything else on you, that can be used against you in the court of law. The only exception is the exclusionary rule. If evidence is tainted, what that means is if evidence is obtained illegally without a search warrant or without reasonable cause, that evidence cannot be used against you in a court of law. And of course, you know this. There are a number of times where searches can be conducted without a search warrant. We're going to come up with a list. You won't need to know these for the test, but students always ask. So generally speaking, if you give consent, if you give your permission, the cops don't need a warrant. The cops don't need a warrant if they have probable cause. They don't need a warrant if stuff is in plain view. They don't need a warrant if it is an incident to an arrest. So if they're arresting you, they have the right to search you. If they are in hot pursuit of you, or what is known as exigent circumstances, basically if they think that you're going to destroy the evidence, they don't have to wait for a warrant. If they are stopping and frisking you, if they believe that you've done something wrong, they have the right to stop and frisk if they believe their safety is in danger. If that's the case, they don't need a warrant. Anytime you are crossing a border, the cops don't need a warrant to search you. If your parents give permission, they don't need a warrant to search you. Sometimes if there are emergency situations that arise, they don't need a warrant. If you abandon your property or leave something on the side of the road, they don't need a warrant. If you are on probation and you have to meet with a probation officer, then they don't need a warrant. And then finally, if they are administering or regulating a business, so if the health inspector is going in to inspect a business and they find something else, that's another situation in which they don't need a warrant. Otherwise, police need a warrant to arrest you or they need probable cause. And again, probable cause generally means reasonable suspicion. If a reasonable person thinks that there's a chance that you might have done something wrong, the cops have the right to search you. And the most common type of reasonable suspicion is when things are in plain view. The cop can look in the back of your car and they see that you've got a bottle of booze, or they see that you've got stolen property, then they don't need a search warrant to search your stuff. They can seize your property, seize your evidence without a warrant if things are in plain view. And again, if they do collect something and they don't have a warrant and they don't have probable cause, things aren't in plain view, then the exclusionary rule kicks in, and what that means is the tainted evidence cannot be used against you in a court of law. Basically, it's as if the cops had never found the stuff. You know that you have many rights that are protected under the Fifth Amendment, which gives you the right to due process. So you have protection against double jeopardy. You can't be tried for the same crime twice. We've already talked about what that means. You have protection from self-incrimination. That is, you can plead the Fifth. Of course, only in a criminal case, but you have the right to not testify against yourself. You also have the right against cruel and unusual punishment. So no tarring and feathering, no waterboarding unless you're in Guantanamo Bay. Generally speaking, those are your rights protected by the Fifth Amendment. And of course, you have the right to an attorney. The trial procedure looks like this. The first step is that you are formally indicted. Just means that you are accused of a crime in court. You are formally accused of the crime. The second thing that happens is a booking takes place. The cops will come out, they will arrest you, they will take you into custody, and they will file a police report. The third step in a trial process is a pretrial release. So if they don't think that you're going to run, if they don't think you're a threat to society, they could set bail, which means you give them some money, then they let you go free, and then as long as you come back to court, you get your money back. The fourth step is the arraignment process. This is where you're brought before a judge and you are officially informed of what the charges are. This is where you're asked to make a plea. You can either plead guilty or not guilty. If you plead guilty, you don't get a trial. Everything is done right there. If you plead not guilty, the next step, of course, is that there will be a trial. But even before we have the trial, we have the preliminary hearing. What they do then is determine, is there enough evidence to go to a trial? At this stage in the preliminary hearing, you have the option to plea bargain along the way. What plea bargain means is usually the government will make a deal with you. If you admit that you're guilty without going through the trouble of a trial, they'll usually cut you some slack and your sentence won't be nearly as harsh. The sixth step is we actually have the trial itself, and then depending on the outcome, if you are found not guilty, then you go free, or if you're found guilty, the sentencing takes place. So if we want to kind of look at a more complex version of that, you can see this from your textbook or one of the websites. You can see stage by stage how we go through the trial process, but you won't need to know this for your test. That's all I have for you on this unit on the judicial branch. I look forward to talking to you a little bit more about the differences between the types of court systems, but we'll get that in our next lesson. Have a wonderful day.